You sued your doctor for medical malpractice, and now the judge has told your attorney that your case is starting trial next month and that there will be no excuses. Your case is definitely starting on that day. What happens if your attorney or the defense attorney is not ready and not prepared to go forward on that day? Can the judge throw your case out? You want to know the answer? Come join me for a moment as I share with you some remarkable information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, yes, he can. The judge can threaten to throw your case out. The judge could fine the attorney. The judge could do lots of things. There are lots of alternatives and lots of options that the judge has if the attorneys are not prepared to go forward with trial on that particular date. Now, in all likelihood, the judge has given the attorneys plenty of time to get prepared for trial. In all likelihood, the judge has had multiple conferences with each of the attorneys to try and learn whether or not there's the possibility of trying to settle this case. The judge may come to the decision that, you know what, this case is not going to settle before going to trial. So what does he do? He sets this matter down for a specific trial date. Now, at some judges, that's not a fixed date. In other words, if you come in on that date and say, Judge, listen, I have another matter on, I have to deal with something else, I've got to go on vacation, many of these judges will try and accommodate the attorneys. But where the judge turns around and says, listen, I don't want to hear any excuses. You are going to pick a jury on this date. If you're not prepared, I'm going to dismiss your case. That's a hard line in the sand. Now the attorneys have to get ready for trial. Now everybody knows that that date is a fixed date, and if they don't come prepared, ready to go ahead and start jury selection, there is the good possibility that the judge is going to dismiss your case. And if that happens, now you're in limbo. Now a lot of bad things will happen, and it may take a Herculean effort for your attorney to try and wiggle out of it. Okay? Once the judge takes that step and says, hey, listen, I told you there would be no excuses. You're not ready? Case dismissed. And if in fact the judge tells you that the case is dismissed, now your attorney has such a big headache because he may actually have to appeal that decision. So now, on the appointed day, your attorney is actually ready to go. He's got your witnesses lined up. He's got his experts lined up. He has all of his evidence in court that he subpoenaed, all the medical records that he needs. He's got everybody lined up for every single day that trial is scheduled. And he anticipates your case will take about 2 weeks to try. All right. So now, immediately before the judge sends the attorneys out to go pick a jury, the defense attorney raises his hand and says, Judge, I have a problem. And the judge looks at him and says, what's your problem, counselor? He says, Judge, I can't try this case right now. Why not? And now the attorney gives some long-winded explanation. And what does the judge do? The judge looks at his notes, puts his hand up and says, no more. I specifically told you last month there would be no excuses. We are trying this case. If you do not try this case, counselor, I am now going to dismiss your defenses and we are going to proceed forward with a trial on damages. So when the defense is not ready to go forward and has violated the judge's order, you know what happens? The judge can threaten him to dismiss his defenses. Now, what does that mean? So at the very beginning of the lawsuit, when we go ahead and file a summons and a complaint, those are the papers necessary to actually start your lawsuit. When we serve and deliver those papers to the doctor, who then gives it to his lawyer, and then they give it to their insurance company, they have to respond to the allegations that we are making in this claim. And how do they respond to it? Well, they prepare what's known as an answer. It's really an answer to your allegations. You're claiming that the doctor violated the basic standards of medical care. They answer, no, we didn't. You're claiming that the doctor's carelessness was a cause of your injuries. And they respond in their answer, sorry, even if the doctor did something wrong, whatever he did not cause or contribute to your injuries. Another claim you make is, listen, the doctor was careless, his carelessness caused you injury, and your injuries are significant and disabling. And in the defense's answer, they turn around and say, listen, even if we did something wrong and we caused you harm, your harm really is not as bad as you claim it to be. Those are typical defenses that we see. Oh, and by the way, there's one more that they usually use. Hey, listen, we weren't responsible, but if we were, hey, so are you, Mr. Patient. That's known as an affirmative defense of culpable conduct, where you, the patient, are also partially responsible or fully responsible for your own injuries. So going back to the question I raised, what happens now if the judge turns around and threatens the defense lawyer with throwing out their defenses? What that really means is that we get a default win. Now, what does that mean? So imagine the Mets go to play Yankees, right? and now the Yankees don't show up for whatever reason. The Mets get an automatic win. It's known as a default. All right, so now they're considered to be winners for that particular game. Well, if the judge throws out the defense's answer, it's as if they never answered the allegations, which means we get an automatic win. So what happens then? So what happens then is that now we have to have a trial to determine the extent of your damages. And that's all the trial would involve. We would pick a jury and now present evidence and testimony and proof with various medical experts, with various medical doctors, not about whether the doctor was careless, not about whether his carelessness was a cause of your injury. That's already been decided. Why? Because the defense's answer has been stricken and thrown out because they didn't show up. So in that instance, the only thing left for the jury to consider is, how much are your injuries really worth? What are your damages? How much money are we to give you to compensate you for all the harms and losses and damages that you incurred because of the doctor's carelessness? So let's go back to the original question I asked at the very beginning of this video. Can a judge threaten to throw the case out if your lawyer is not ready to go? The answer is yes, he could. Can the judge threaten the defense lawyer for dismissing his answers to the case and giving you a default on the issue of liability and causation? The answer is yes, he could. And it would create significant headaches for each attorney if that were to happen. Why do I share this great information with you? I share it with you to show you exactly what occurs in these medical malpractice cases, in these accident cases, and even these wrongful death cases here in New York. You know, I do realize you're watching this video because you have questions and concerns about your own matter. Well, if you're thinking about bringing a lawsuit but have not done so yet, and your matter did happen here in New York, what I invite you to do, if you still have questions, pick up the phone and call me. I can answer your legal questions. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.